Hello everyone, thank you so much for tuning in. I'm super excited to have you watching this video. My name is Mary. I'm a practicing lawyer in Nigeria, and on this channel I share videos to educate the public. I also share videos to help law school students on new weeks. If this is your first time on my YouTube channel, please do what to click on the subscribe button and do not forget to put on your notification bell. Okay, if you enjoyed this video, if you like this video, do not forget to give it a thumbs up and also drop a comment for me in the comment section. Today's video, I want to share how to tender a document in a Nigerian court. So this video is basically for law school students and new weeks, like lawyers, barristers, and equity. Okay, so I actually made the video on how to lead your witness in examination in chief, and that is part of trial in Nigeria, be it civil or criminal. My previous video on how to lead a witness in examination in chief, and this particular video on how to tender a document in a Nigerian court, they're actually parts of evidence in Nigeria. Okay, so you cannot do without these stages in any be it civil or criminal case in Nigeria. So let's just dive into it. The first thing I would love to mention is that there are actually two ways to tender documents. We have what we call disputed documents and undisputed documents. So oftentimes you see documents that are not controversial, they are not contentious. That you see lawyers tendering it from the bar. But when there is a document that is contentious, it is disputed. Okay, you see the counsel tendering that document through a witness, and the other counsel will be given the opportunity to either object it and or to tell the court that there is no objection as to it. So it is important for you that when there is a disputed document, you need to raise necessary objections. And I also made a video on necessary objections you may raise in trial, during trial. I talked about objections you may raise to a document, and also objection you may raise during giving of evidence, either when the witness is given evidence or when a document is up, it's sought to be tendered. Okay, so let's just dive into it. So this video cannot stand alone. It's actually in line with the previous video on how to lead your witness in examination in chief. So there is an aspect, there is a particular stage where you have to tender documents. That is if you have documents to be tendered. In that case, there are situations whereby you would not have documents to actually tender. Okay, but there are also situations whereby you may have documents. So when you have documents to tender in court, when your witness is done adopting the civil case, so you need to watch that video. I will try and link it up here. After your witness must have adopted the written statement on oath in civil case, so it is important for you to watch that video so that you'll be able to understand better. So when your witness must have adopted that written statement on oath, the next question will be that you need to ask questions in line of the document that it needs to be tendered. Okay, so you can check and I said in your written statement or note, you need to, before sitting, before you get to court or when you get to court, before your matter is being called, you must have identified the paragraphs that have documents that you actually pleaded document, probably paragraph 2, paragraph 4 and 5. You must have listed them somewhere so that you will not waste the time of the court while trying to get the paragraphs. Okay, so then you ask the witness, after the written statement on oath must have been adopted, then you ask the witness, a witness in paragraph 4 of your written, now we are tendering documents, we're about to tender documents. In paragraph 4 of your written statement on oath, you made mention of a tenancy agreement. If you see the said tenancy agreement, will you be able to identify it? Just make sure you can write it down if you're preparing for a trial, and that will be your first trial. You can always write it down. Okay, so you made mention of, in paragraph 4, you made mention of the statement tenancy agreement. If you see the say tenancy agreement, will you be able to identify it? So the witness will answer in affirmative, that is yes. And you ask, how will you identify it? You can say maybe by my name is on the document, my signature is also on the document, and probably just things that you can use in to identify the document. If it's a document that has a passport photograph, you will say same that my passport photograph is on it. So then after asking, will you be able to identify it? And they say yes. So you apply to the court that the document be shown to the witness. Okay, so the clerk will actually approach you to take the document to meet the witness in the witness box, and then you ask, is that the document, that the tenancy agreement? You will answer in affirmative, yes, this is the tenancy agreement. And then if that document, it is important, before you seek to tender it, the first thing you did is to seek to show it to the witness. and the clerk will approach you. Once the witness identify the documents as being the same document you mentioned earlier, you need to apply to the court for same to be tendered and admitted in evidence. But before you do that, if that document is very important, okay, that is why you can always list your questions so that you will not forget. Okay, so you ask if that document is a secondary evidence, that is, if it's a photocopy, you need to lay foundation. If the documents, like you just need to lay and you just need to check before going to court whether your documents are actually it may be relevant, but are they admissible. The tenancy agreement, for example, if that case was a case of probably you want to evict a tenant, okay, so a tenancy agreement will definitely be relevant to that particular case, but is it admissible? If it's a photocopy, it is not admissible as a general rule, but you need to lay evidence to either, okay, why are you bringing a photocopy to the court? Probably you say the original copies are actually within the custody of the other party and they are not willing to provide you same, or probably you can't find it. You just need to lay foundation to why you're bringing a secondary evidence to court. So if you omit that stage, the other counsel may actually raise objection to it, okay, and once objection is being raised to it, at that point you cannot really start laying the foundation. You may have to just withdraw the document, because if you enter argument with that particular counsel, your document may be marked tendered but rejected, and you will not be able to tender that document again in that trial during that for that case. Okay, so it is important for you to be very, very alert and prepare for your case. So that is important. So you ask once you ask, I know I actually digress a little, but they're actually important points. But let me just recap the question. Refer to the paragraph where you mentioned documents, okay? And you ask that you made mention of a particular document in paragraph 4 of your written statement on oath. If you see the document, will you be able to identify it? You will answer yes. So that is the first question. And how will you identify it? By my signature, by my name, and you apply to the court that the document should be shown to the witness. The clerk will come and show the document to the witness, and you ask, is that the document? You will say yes. Witness, that tenancy agreement is actually a photocopy. Where is the original of the document? Then you will say the original is in the custody of the plaintiff. You just say wherever the original is, just for the court to be aware that, okay, this is why you can't you could not bring the original to the court. So then you ask, once you say that, once the witness respond, you just take the court, we seek to tender these documents as evidence support of our case. So once you say that, the clerk will take the documents and show to the other counsel, because you're already seeking to tender it, and the court need to either say yes, document is rejected, or the document is admitted and marked as exhibit ABC, or something like that. Okay, so once you say that, you have to sit, because the other counsel also need to check the documents. Two lawyers cannot stand at the same time in the courtroom, okay, cannot address the court at the same time. So you have to sit. Once you apply to the court for the document to be admitted, so you have to sit for the other counsel to check through, is it dated, is it truly signed, is that witness the maker? You just quickly check, okay, as this counsel actually lay evidence, this is a photocopy, as the counsel lay evidence as to why they could not produce the original. It will just think within a few minutes. Either I will say, my lord, we are objecting to this document. This document is a public document, and same is actually relevant, but it cannot be admitted, blah 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 blah. We just say a lot of things. So you, as the other counsel, you need to react to that. And as a new week, because I believe many of my videos are actually, oftentimes you see new wigs watching my videos, so you now think like, okay, what can I say, what should be my response to this particular objection and all of that. So you can always, sometimes it is good for you to just ask the counsel, like, what do you think, like people in the bar, they may help you, but they may not be conversant with your facts, and they may not really be able to actually help you with the actual response. But just make sure you are smart about it. If what the other counsel, the opposing counsel, is saying something that is relevant, the best thing for you to do is just to withdraw your documents. If you think what he's saying is meaningful, that it's actually a good basis for an objection, okay, just withdraw the document. You may try and use another witness to tender that document. But when you engage in argument like this, you actually try to respond to that objection, and if your response is actually something that is not founded in law, like you're not sure of what you're saying, documents may be marked as rejected. Okay, so you need to be smart. You just need to check if the council objection is something that is quite reasonable. Probably you just have to withdraw your document. Okay, and if there is no objection, it will say that there is no objection, and then the court will mark it as exhibit. Okay, and that is how you do for every of the documents you need to tender. In some cases, the court can say you should tender the document all at once. That is in order not to waste the time of the court. You can just identify in paragraph 4 of your written statement on oath, in paragraph 6 of your written statement on oath, paragraph 7, paragraph 8, paragraph 9, paragraph 10. You made mention of documents of maybe tenancy. You just put everything together, like in paragraph 4, 5, 6, 7, and 8, 10, 12. You made mention of the tenancy agreement, of the certificate of occupancy, of this, of that. If you see the set documents, will you be able to identify them? And you answer. It's just the same process, but you are putting, instead of you asking those questions one after the other, one after the other, you can just ask everything together. But as a new wig, I will not advise you to do that. Just take it one step at a time. Each of the documents, tender them one step at a time. But if the court say, can't say, can you just tender the document all at once? Then you can do that. Because some judges may actually notice you as a new wig and see you as being lazy. Okay, and I wouldn't want any judge to actually take notice of you based on that, on things like that. So try and tender it one document at a time. If the court instructs you to tender them all at once, then you can do that. Okay, so I think that is basically all I have for you on how to tender document through a witness in a Nigerian court. And I hope this information educates you. Please and please do not forget to like this video. It is important. That's where you help me to make my videos to actually reach a lot of people. But if you're just watching, no comment, no like, you're not really, you're not supporting what I do. Okay, so your act of support is also like this video. If you can share it, if you're a new wig and you have a group of lawyers, a group of new wigs probably from your school, drop this video for them. I am so sure that it will help many of them. Okay, because while I started practicing, I actually did not have that opportunity to start watching videos on YouTube on how things can be done and all of that, but you have that opportunity on the platter of gold, and I want you to use it and appreciate it. So please do well to like this video, comment if you have any question, and if you don't want your question to be that will be seen on the comment section, you can always send the question through my email. My email address will be in the description box. Thank you so much for watching, and I will see you in another video.